Mr. Seidle, I'm going to be advising you of your rights. First, however, the prosecutor will hand you a copy of the complaint and advise you of the charges. Mr. Lemieux.
Thank you. Mr. Seidle, under the warrant 1303-W-2015-001192, you have been charged first count of murder by purposely or knowingly causing the death or serious bodily injury resulting in the death of T.S. You're also charged with knowingly possessing a firearm with the purpose to use it unlawfully against the person of T.S., the second-degree crime. And you're also charged with endangering the welfare of a child for having the legal duty of care over your daughter, and at that point in time, you caused your child harm that would make her abused or neglected under Title IX. Here's a copy of the complaint.
The record will reflect that Mr. Lemieux handed the defendant a copy. You say can and will be used against you in a court of law. You have the right to be represented by counsel. If you cannot afford an attorney, one will be appointed to represent you. He's here with you this afternoon. You have the right to a hearing as to probable cause. You have the right to be indicted by the grand jury. You have stated them. At this time, would either the prosecutor or defense counsel wish to be heard on the issue of bail, or would you prefer to make a more formal application at a later point in time?
I wish to be heard now, Your Honor, and depending on what the decision is today, we'll supplement it with a more formal application if we need to.
Let me just, as part of your argument, as for the conditions of bail, I'm inclined to direct that the defendant, with his children or any members of the deceased victim's family, I'm also inclined to direct that he not be permitted to return to the deceased victim's residence or any other location where the children might reside. And finally, that the defendant would have to be required to comply with any conditions that might be imposed by the Division of Child Protection and Permanency. So,
Your Honor, I understand those preconditions. I would say to the extent that the defense counsel or the defense team needs to speak to anybody in the Seidle family, any of the children, or any other members of the extended family, that such an order would not apply to us.
absolutely not.
In that regard, the bail as presently constituted is at $2 million, no 10%. When I look at the bail guidelines, Your Honor, the guidelines for criminal homicide with which Mr. Seidle has been charged has a bail range of between $250,000 at the low end and $1 million at the high end. So on that guideline range of $50,000 to $100,000, and an allegation of endangering the welfare of a child, with which there is a bail range of $50,000 to $100,000. But even if we put all of those consecutive, so to speak, that's a total of $2 million as opposed to the $2 million as the president stands. Mr. Seidle stands here today notwithstanding the charges, presumed not guilty. He has absolutely no prior criminal record. He has absolutely no prior official domestic violence record. He is an honorably discharged military veteran from the United States Navy. He has proudly and honorably served the Neptune Police Department and Neptune community for 22 years. Well respected and still is, and very well regarded and still is, member of the Neptune community and the law enforcement community. He has, as I've said, absolutely no criminal record. He has a residence in Neptune in Monmouth County. I'm not going to put the address on the record. I can share that with the court otherwise if it needs specificity. If he is released, he would continue to reside in Neptune. There are several members of his extended family, his side of the family, that are here today that would vouchsafe his appearance. He has retained private counsel, namely our firm. We intend a vigorous investigation more to this case that meets the which won't be addressed today, Your Honor, understandably, but which we intend to investigate and reveal at the appropriate time. Would remain offense-free and would otherwise comply with any instructions of the court, including the ones Your Honor has preconditioned. I don't think that he plans on any travel outside the country, but if they wish, even even though it's unnecessary, he's a very upstanding member of the community. If there was a requirement that he checks in once a week or once a day or would not object to that as well. Obviously, he's charged with very serious offenses, and to best defend him in most ethical perspective should be accommodated constitutionally by the bail. I would respectfully submit, Your Honor, that a bail at the low end of the range, given his otherwise unblemished announcement in Neptune Township, a bail at the low end of the range with a no 10% option, somewhere between $250,000 and $300, would more than guarantee his appearance. Bail be at the low end of the guideline range, and certainly at a minimum, somewhere within the guideline range, and not twice as much. And I say that with all due respect to the judge that set the bail, but I'm in a unique position in that regard. Thank you.
Thank you, Mr. Bertuccio. Mr. Lemieux.
Thank you. When bail was set yesterday before it was thought about, the fact of the matter is that, yes, Sergeant Seidle is someone who has been in the law enforcement community for a long period of time. I can say that I've worked with him myself. But the fact of the matter is that when he was out on the street yesterday at 11:26, he was no longer a sergeant for the Neptune Township Police Department. He turned into a criminal and a murderer. And the reality is that when we look at the bail guidelines in this particular case, and we look at the seriousness of the crime and the likelihood of conviction, this case could not be more clear-cut when it comes to Mr. Seidle decided to make a conscious decision in his vehicle to run his ex-wife off the road, get out of his car with his service weapon, a .40 caliber Glock handgun, go over to her driver's side window and fire inside that car, not once, not twice, but multiple times. He does this while his own daughter is located in his passenger seat in his vehicle. When you look at this type of crime and you look at what we're looking at in this particular case, there can be no question that his conduct was purposeful and or knowing, and that's what will be required under the murder statute. Furthermore, in looking at this particular case, his acts of yesterday would put him in a situation where he is eligible or could be eligible for life without parole. There will be one of the aggravating factors that the state will be seeking against Mr. Seidle, and he will be looking at life without the possibility.